Hello everyone, Assalamu alaikum. I am Raihan Mustafa Asfi. I hope you all are keeping well. Today I am presenting the landmark case of Bangladesh, MD Abdul versus Government of Bangladesh, 10 SCOB 2018 High Court Division. The name of the parties of this case: petitioner MD Abdul son of late Abdul Rashid, residing at 2/404 Eastern Rokia Tower, 98 Boromog Bazar. Respondent, Government of Bangladesh, represented by the Secretary of Ministry of Land, Justice Obaidul Hassan and Justice Krishna Devnath. In this case, we found 4 facts. Number 1, the EPA was first established under the 1962 Constitution of Pakistan. Number 2, continue under the Pakistan Defence Rule of 1965 Ordinance on of 1969. Number 3, the Enemy Property Act of 1974 attempt to repeal this ordinance but faced criticism. Number 4 and final fact is successive governments continued listing properties as enemy property after 1974 dispute judicial and legislative shift in Bangladesh. Then come to the next point, issue. With issue, here we have found 5 issues. Number 1, whether properties listed as enemy or vested property after March 23, 1974 are legal. Number 2, whether the 1976 ordinance which is granted by the government for the purpose over enemy property is lawful. Number 3, intermediation of judicial decision ensuring compliance with previous Supreme Court's ruling. Number 4, or whether rightful owners of heirs should regain possession of the property. Number 5 and final issues is that they need for compensation legislative action and address the issues. Then rule of law. MD Abdul versus Government of Bangladesh and others case touches upon constitutional law, human rights law, property law. It examines the legality of historical legislation under the voice constitution and its alignment with the principle of equity, human dignity and social justice enshrined in the Bangladeshi constitution. Then application. The case was initiated through an application under Article 102 of the Constitution of Bangladesh, leading to the issuance of 2 rules nishi. In the first rule nishi called upon the respondent to show case why the 1976 ordinance and subsequent action should not be declared void. The second supplementary rule challenged upon Section 3 of the 1974 reasoning. In this case, we found mainly 3 reasons. Number 1, observation of the 1960 Constitution of EPA. Number 2, legality of post-1974 listing. Number 3, 1976 ordinance. Observation of the 1962 Constitution of EPA, it means the 1962 Constitution imposed by a dictator making EPZ was problematic. EPA was subsequent ordinance continued the historical errors and followed legal foundation. Legality of post-1972 listing properties listed as enemy or vested property after March 23, 1974 are illegal. Officials involved in post-1974 listing are liable for illegal action. 1976 ordinance of 1976 has been declared illegal and void by higher court. Then next point is argument. For the respondent, for the petitioner, for the respondent's attorneys is MD Mahabube Alam, Deputy Attorney General MD Jahangir Alam, and against Attorney General Sharmeda Nath Bishwas, MD Josimuddin and Shafiqul Hussain. For the petitioner, advocate MD Mohammad Imtiaz Farooq and Mr. M.A. Syed Ahmed. For the respondent, government aim to manage property service nation interest and legal observation. For the petitioner, advocate MD Imtiaz Farooq and MD M.A. Mahmood. For the respondent, legislative measures and address illegal issues. Now come to our next point, argument. For the respondent, for the petitioner. For the respondent, Attorney Mr. Mahbube Alam, Deputy Attorney General Mr. M.D. Jahangir Alam, and Assistant Attorney General Mr. Shamendra Nath Bishwas, Mr. M.D. Jasimuddin, and Mr. Shafawat Hossain. For the petitioner, Advocate M.D. Imtiaz Farooq and Mr. M.A. Syed Ahmed. For the respondent, government aim to manage properties serving nation interest and legal obligation. For the petitioner, 1976 ordinance contradicts the principle of Bangladesh independence. For the respondent, legislative measures and amendments address historical issues. For the petitioner, successive governments' action disposed rightful owner primarily affecting Hindu monetaries. The next point is decision. Decision, the implementation of judicial decision, restriction of legislative measures, promoted implementation of tribunal and appellate tribunal decision. Implementation of judicial decision requires that ensuring strict compliance with previous Supreme Court ruling. Then next, restriction and legislative measures. Government official must not list properties as vested in future. Establishment execution tribunal and district to handle application under the 2001 Act. Promote implementation of tribunal and appellate tribunal decision. Use unclaimed properties and human development and honor original owners. Provide the fair compensation to lawful and claimants for non-returnable properties. 1974 listing of property as enemy property illegal. It emphasized that need for legislative and executive measures to rectify past errors and ally with the objective of the 2001 Act and amendment in 2003. The judgment enforced the government officials who listed properties as many properties post 1974 acted illegal and could illegal consequences. The court issued several directives. Number 1, provision on future listing, tribunals, adherence of time frames, application of the Limitation Act, implementation of tribunal decision, special appellate tribunal, use of unclaimed vested properties, legislative and honoring original owners, and last and final judgment is fair compensation. Opinion. The judgment underscores that courts committed to addressing historical injustice and ensuring adherence to constitutional principles. It recognized the wrongful dispossession for properties for minority continues and the need for fair and transportation process for the restitution. The court's directive aimed to create a legal framework that respects property rights and ensuring the justice of all. The legal representation. Course of observation impact on legal and social, politics, ethical and immoral. Conclusion. Last and final point is conclusion. The case MD Abdul Haq vs. Government of Bangladesh landmark judgment addressing the injustice associated with the Enemy Property Act and subsequent amendment. The court decision reaffirms the principle of equity, human dignity and social justice, holding government action to account and providing the framework or legislation reform. The judgment not only reflects past wrongs but also set a forward-looking agenda for property rights and monetary protection in Bangladesh. Thank you everyone. If anyone have any question, feel free to ask me. Thank you.